Thank you for joining us on this episode of Legal Angle with Emmanuel Olawale. My guest today is someone who has spent most of his professional life in the courtroom in different capacities as a bailiff, as a prosecutor, as a magistrate, and currently as a judge. His name is Jim O'Grady. We will be talking about small claims court and what you need to know if you want to file a claim or if someone filed a claim against you. Welcome to the show, Judge.
Thank you very much for having me.
Thank you for coming. Can you please tell us more about yourself?
Certainly. I was born here in Columbus, Ohio, born and raised on the north side of Columbus, grew up in the Forest Park neighborhood, graduated from Northland High School, started working in the Franklin County Municipal Court in 1992, working for Judge Richard Farrell as his bailiff. I worked for him as well as one other judge as a bailiff for 15 years in the municipal court. During my time as a bailiff, that's when I went to undergrad and to law school. At the tail end of my 15 years as a bailiff, for the last 2 years, I also spent time part-time as a magistrate in small claims court. So I did that in addition to being a bailiff. Most of my bailiff duties would end sometime around early afternoon, and I was able to schedule a later afternoon docket to handle some small claims cases. So I did that for about 2 years. I then moved on to the Franklin County Prosecutor's Office, worked in the prosecutor's office in the juvenile division, the grand jury division, and then on the trial staff division. Worked there for right around 5 years. Then in 2011, I was elected to the Franklin County Municipal Court bench, and that's where I've been for the last 10 years. Been a judge here in the Franklin County Municipal Court. I have 2 daughters, Riley and Violet, 13 and 8, and they keep me plenty busy and on my toes.
I can only imagine. I have an 8 and 14-year-old too.
There you're right along with me.
Yes. You earned your bachelor degree in political science and history. And
Correct,
it seems
yeah.
like you've always been predestined to go to law school to become a lawyer.
Well, my father
What
was a lawyer.
inspired that?
Oh, sorry. Yeah, my father was a lawyer. He was a county prosecutor in the 60s and 70s, and then he was a judge he became a judge in 1981. So I grew up down here at the courthouse. Back in the 70s, my mom worked as well. She was a nurse. So when there were times when school wasn't in session, my dad would bring me down here to work in the courthouse, and I would kind of tag along with him. And so I started at a very early age, getting to sit in courtrooms, watch trials. I got to watch my dad in trial several times, watch some of the other prosecutors and defense attorneys here in town in the 70s and early 80s. So, you grow up watching what your dad does. It wasn't a stretch for me to then want to go to law school. And my dad, I've always been a big history person. So my dad was a history person as well. So I got that from him. I knew what I wanted to do eventually was to go to law school and work in a courtroom on a daily basis. And I was fortunate enough that, even as a bailiff, I was in a courtroom every day. So I've spent for the last 29 years, I've been in a courtroom working every day, which has been incredible. I truly enjoy what I do. I enjoy being in the courtroom, helping people. It's great. So yes, I've known from a very early age on what I wanted to do as an adult.
That was very inspiring. It seems like you've always been a legal apprentice since even before you became of age. Do you have other family members apart from your father that's also a lawyer?
No, I'm the only one of. I have a sister, 2 sisters, and a brother, and I'm the only one of the 4 of us that are lawyers. That's a lawyer.
Yeah, your father must have been very proud of you that you chose to seek that career.
Yeah, absolutely.
Yes. And you mentioned that you worked as a bailiff for 2 judges, that is between 1992 and 2007. And you even started working as a bailiff even before you went to law school. What was that like?
I actually started working as a bailiff before I even went to college. I Yeah, I started for about my first 6 or 7 months as a bailiff. I hadn't yet started college. It was great. What an experience it is to be in the courtroom every day, work with some of the finest attorneys in town. It was incredible. It was an incredible experience to get to work side by side with these people and just learn from them. And that's what I did. I soaked it all up every day. I got to be around some of the finest attorneys, and I had that as well growing up. Having a father who was a prosecutor, I got to sit and watch people like Ron O'Brien and Mike Miller, and just several other fabulous attorneys here in town. So it was a great experience to be in a courtroom every day. And then it made me want to get through undergrad as quickly as I could and get through law school, because I wanted to get to do what I was seeing every day other people do. So it was a great place to work while you're going to school.
I can only imagine that. And you went to law school. You are already a bailiff. You've spent most of your life in the courtroom. What was it like for you going to law school like a normal student, when in fact you know that you are already in the system?
Well, that was an interesting perspective, because as you know, law school kind of teaches you different things, not necessarily the inner workings of how a courtroom operates. It's much more legal theory and things of that nature. So there were times in law school where you're being taught something and you realize, well, that's not exactly how things are in court every day. So it made things a little more difficult from that perspective, that I most definitely had to kind of take a step back and realize, look, what I see every day in court isn't necessarily what my professors want to hear. I really had to, I thought that my court experience would translate better into classes in law school. And it didn't take very long to realize that, one, your professor isn't impressed at what you do for, what might. Looks like I cut out there for a second. Made me realize that I had to, kind of drop the perspective of being in court all the time, and, do it more as the professors expect you to be in law school. More of the theory. A lot of times I had a tendency to want to shortcut things, on answers to things that I would just kind of, how it is in court. And no, you really have to. You learn quickly in law school. You lay everything out. You don't leave anything out, when you're answering a question. So it didn't take long for me to realize that they didn't necessarily, by working here, didn't translate to being in law school and help me in my classes at law school, with the exception of, criminal law. Outside of that, pretty much, being in a municipal court, we didn't have, some of the other classes that I had. Those issues never came up.
That was interesting. And then you worked as a magistrate for about a year, handling small in the small claims court. What are the kind of cases that you handled as a magistrate?
Well, you would have all kinds of cases. Small claims is definitely somewhere where you can have some very interesting cases, and that can run the gamut of things. I had my first case when I was filling in as a magistrate was very interesting. It was, it was just a case about a car. Somebody took their car to one of their friends who had a shop that did car repair, and he didn't feel that he did a good job and took too long, and so he was suing him for the money that he had paid him and the damage. I think he indicated that there were some additional damages that were done to the car while it was there. So I get in the courtroom. It's my first time ever handling any kind of a matter between parties, and it was two gentlemen from Somalia who were in this litigation, and so we had 3 interpreters in the courtroom, and it was a very interesting experience because everybody needed an interpreter. So everything takes much longer there, and you have to be a lot more patient. And it was just, small claims court, you tend not to be nearly as formal, because really you just want the parties to tell their side of the story, because neither of the parties had an attorney. And that's a lot of what you see in small claims court, is you'll see parties who are unrepresented, because it is, the monetary amounts are much lower. And what we want out of our small claims court is we want people to be able to resolve a legal dispute, and just to be able to come in and tell their side of the story. And so as the magistrate, you kind of have to help out both parties a little bit, or at least, kind of coax out of them sometimes, what it is that they're alleging took place. So it was a very interesting experience, as it was, my first time being on the bench. It was my first time handling a trial. And then I have 3 interpreters in there who are, interpreting everything. And there were points where, because it is somewhat casual, there were points where, one party would ask the other part, would ask a witness a question, and then it would be interpreted. And there would be a long interpretation, and then the interpreter would tell me, well, he says yes. I'm like, well, it seemed like he was saying a lot more than that. And so it took a while for, like, I need you to tell me everything he's saying. I want to hear all all of his arguments, so that I'm catching everything that he's trying to relay to me. So it was very interesting. One of our another judge here, Judge Hummer, was a magistrate at the time as well, and he just came down to watch and make sure that I was okay in my first trial. And he sees that I'm in this trial between, one guy suing another guy over some damage to a car, and I've got 3 interpreters in the room. And within about a minute, he just looked up and went, "All right, you'll be good," and left. And I thought, well, all right, I'm on my own. It was, but it was very interesting. It was very all the cases I did in small claims obviously helped out in my career. You're much more in small claims. You're much more mediators at times, because you do have parties that aren't attorneys, and so a lot of times you basically end up just kind of tell me your side of the story, you tell me your side of the story, and then maybe you'll ask some questions if they don't get out some of the questions that you feel are relevant. So it's a great court. It's a great resource for people, because you don't have to be an attorney to go in there. And like I said, the magistrates do an incredible job of assisting people as much as they legally can. We're prohibited from offering legal advice, things of that nature. But they do as much as they can to try and help people resolve their cases as quickly and as efficiently as possible. But at the same time, also help people to maybe get out all of the relevant information they can from their case that people may not remember to do.
Thank you. And what is the process of filing a claim in small claims court?
Well, one of the great things we have now is we have a website, which, as hard as it is to believe that we're in 2021, that this year we just launched a website for the court. It used to be just the clerk, but there's a website. It has a small claims division tab on it that you can go to, and it has all of the documentation there that you need in order to file a complaint. So it's got a template of a complaint form. You fill in the boxes, and then you would file that, and it's $78 to file with the clerk of courts, and they're located at 375 South High Street on the 3rd floor of our building. So you can go to the website, fill out all the information, print it off, take it down here to the courthouse, file it with the court. Then you'll get notice within the next couple of probably about week to 10 days, once they get service on the defendant, of what is going to happen from them. The defendant has an opportunity to respond. Once the defendant responds to the complaint, the case is then assigned to one of the magistrates. So Lori Tyak's office is where you go to file your complaint.
Okay. Yeah, is it possible in a case where a defendant did not file an answer and they just show up in court? Can they do that?
Well, no, you need to file an answer first. Otherwise, you're subject to getting default judgment. So no, you would need to file an answer. If you did show up in court and indicated that you wanted to file an answer, the magistrates are going to be understanding of that. We see plenty of times where someone doesn't respond to a complaint and then judgment is granted against them. They can just file at that point. They can file an answer, and the court's pretty lenient as far as undoing that, accepting the answer, and then setting the case either in front of the magistrate or even for mediation. We have great mediation options available here in the courthouse. And all of us, both the small claims division and us as judges, really rely on the mediators for their services. We have both in-person and online mediation. We also have same-day mediation. So what that means is whether it be a small claims case or even a civil case that's in our general division, if the parties decide that they want to sit down and talk with a mediator, they can make that decision even on the day that the case is set for trial, or if it's set for pretrial. We can pick up the phone, and we have somebody in-house here from either Capital University Law School or the Ohio State University Law School who will do the mediation for them right then and there.
Thank you. You mentioned default judgment. There are people watching that don't know what that means. What does it mean? What does default judgment mean?
So if you don't file an answer, when you're sued, somebody's going to send notice. The clerk is going to send notice of the lawsuit to you. So they're going to send you a copy of the complaint. And then what you need to do is you need to make sure you respond to that complaint. And so you file an answer. And again, what you can do is you can go to the court's website. And the court's website, if you go to the small claims tab, actually has an answer there for you. And so it's a template. It doesn't have the language that you need contained in it, but it does have, where you would put the case number, the case name, and then it has an area in the middle of the page where you would type up your answer. And then you type that answer, you sign the document, and then you bring it down to the court and you file it with the court. And that's your answer. And that prevents you from getting what is called default judgment, which is judgment against you because, so if somebody sues you for $1,000 and you don't respond, they get judgment against you if you don't answer. That's called a default. And then they're going to proceed to execute their judgment and try and get their money. You can undo that if you have a legal reason to do so. And like I said, with the small claims cases, we're fairly liberal about, if somebody just says, hey, I didn't know what I was doing, I didn't realize that I needed to file an answer, then we can undo the default, give them an opportunity to file an answer, and then go forward from there. Because at the end of the day, we want a case to be heard on the merits of the case. We don't want some sort of someone's not a lawyer, they don't know to respond. Well, now you get judgment, and if you didn't, judgment against you, and if you have a defense, we want you to be able to present your defense.
Thank you. And what is the maximum amount that someone can sue for in small claims court?
$6,000 is the limit. So it has to be $6,000 or under.
Okay. Can someone demand a jury trial in small claims court?
No, not in small claims court. You can only do that with the general division. So what you could do if you were sued in small claims court is you can then ask the court to transfer the case to the general division. And at that point, you then could ask for a jury trial for the matter in front of a judge. That I have never seen that happen here out of a small claims case. And even our general civil cases that get filed before that come straight to the judges, it's very seldom that you see a jury trial. Like I said, I've been in the courthouse for 29 years. No courtroom that I've ever worked in has had a jury trial on a civil matter. It's just not something that you see very often in municipal court.
Can someone file a lawsuit involving real property in small claims court?
I don't believe you can, no. And I don't believe you can't file against the government. There are some criteria that you can't file on for small claims. I can't remember exactly all of them, but they are listed on the court's website. It does tell you which things that you are not permitted to file in small claims court.
Is there a general timeline for cases in small claims court? They're from the filing to to judgment?
Well, I wouldn't say that there's some of it can just depend on when people are available. So, if you're asking how long a case takes in small claims court, it's certainly much quicker than in the general division, simply because they have a smaller caseload and there's less of those cases filed. It's relatively quick. I would say you're going to have a court date probably within 45 days of filing. And regularly, the magistrates, there's 5 of them. They all hold dockets every day during the afternoons doing small claims. They try and keep those dockets going pretty efficiently. So I would say within 60 or 90 days of filing a complaint, you have a reasonably good chance of having your case resolved.
If one of the parties is not happy with the judgment or decision in small claims court, do they have the ability or the right to file an appeal?
They do.
Okay.
Within 14 days of judgment, you have a right to appeal, to file what's called an objection to the magistrate's decision. You need to make sure that you do a couple of different things when you do that. You need to make sure that you provide a transcript as well as legal grounds for the judgment to be set aside. So you do get a little more into a technical area at that point, where you may want to consult an attorney, because there does need to be some legal grounds. And not to say that someone who's not an attorney can't come up with the legal grounds and can't articulate it in an objection. But you would want to make sure that you had all your T's crossed, I's dotted, to make sure, because at that point it is going to go to a judge, and the judge is going to make a decision on whether or not you have legal grounds. And if you were to lose your objection at that point, you would have to file an appeal. And now you're talking about, having to hire an attorney in the Court of Appeals and more filing fees. And at that point, if we're talking about a small claims case, it might not be worth your while, because you're talking under $6,000, and to file an appeal in the Court of Appeals is certainly going to be a little more pricey.
Yeah, can people seek reimbursement for attorney's fees in small claims?
You cannot.
And there's a cause of action called plevin, which is they asking someone else to return a property that belongs to you. Can someone file a claim for that in small claims court?
Ooh, that's a good question. I'm not positive on that. I don't think so. But I would have to look that up and get back to you. That's a good question. I'm not positive on that.
That's fine. Thank you. And while as a judge in the municipal court, apart from you just deciding cases, you've also done some other things. And one of them is being one of the people that created the first LGBTQ domestic violence counseling program. Can you tell us more about that program and how you helped created that program?
Absolutely. Yeah, what it's called is the CAPIT program. It's an incredible program. It's the only one of its kind in the country, which at the time we created it, I was stunned that there wasn't another program like this around. And I'm really surprised that ever since we did create this program, that nobody has copied it and created another one. But what it is it's a program for individuals who are convicted of domestic violence who are in the LGBTQ community. And what we found was that the counseling services that we had in place for people who are on probation out of a domestic violence case, we really had kind of a one-size-fits-all model. And it was very, what we might call an old school model. We just hadn't thought outside the box, and really hadn't thought of how the counseling should operate and who it should be directed towards, and the whole dynamic of and the makeup of the counseling sessions. So what we did was we sat down and worked with our probation department. It was primarily myself, Judge Paley, our head of our probation department, Bravo, Equitas, Stonewall, Columbus. For a while, we actually even had the Ohio Department of Rehabilitation involved. And then we had some counseling agencies involved and said, here's what we want to do. we want to have counseling programs that are specific to defendants in this community. And so we had to start from scratch. I mean, we brought in professional counselors who even said, wow, there's only a couple people in the country that handle this specific type of counseling. So we had to start the curriculum from ground zero. It took a lot of meetings. It took us about a year and a half to really get everything in place so that we could start the program. And it's run by Equitas. It's a 2-year program. And what we found from individuals who have graduated from the program is, it's really helped them. And they were appreciative of our innovative thinking and how forward thinking we were to have a program that really addressed some of the issues that they were having in their lives. And it was great. It's just been great. It's great as a judge when you see someone at their lowest point, and then you guide them and give them the resources and the tools to help them improve their situation, and they do. And then when you see them, 2 years later when they're graduating from the program, and they're thankful to us for giving them an opportunity. And my position is always, you did this. You did this for yourself. You put in the work, and you've turned your life around. It's been an incredible turn. And so, as a judge, it's great to see that. Because at the end of the day, what I want is, I don't want people coming back to see me. I want to, I work in an industry where I don't want repeat customers. So, it's incredible. And, it really helps people, improve their lives, understand what it is that, why they had a reaction in their situation, why they did what they did. And, it improves their relationships, just everything about their lives tends to be improved from there. And it's great. And Equitas does an exceptional job. All of the individuals we have, the probation officers and all the individuals who work the program are fully committed to it, and they love what they do. And so it's been great to see. It was, I was a small part of it as a judge. You kind of direct it and you throw out your ideas, but the ones who are there every day and who are doing the counseling with individuals, they're the real heroes of the program. It's just been great, and I'm incredibly proud that our court, and it's not just I may be the one who sat in the meetings with Judge Paley and kind of came up with the concept, but the entire court was behind this program, and so it's been great.
Oh, that's awesome. And you mentioned seeing them after 2 years. Is that how long it takes to get through the program?
Yes, it's a 2-year program. And then we have a graduation at the end of that 2-year period, where myself and Judge Paley they usually do it at Equitas. We'll go to Equitas and they'll have a little ceremony there, and we'll come down and present them with a certificate, and other probation officer will be there as well. And yeah, it takes 2 years each time.
Is the program only for defendants, or can victims also sign up for it?
No, it's only for defendants.
Okay. What if do you have to be within the legal system, that means being charged with domestic violence, before you can enroll in the program, or can people who have not yet been charged decide to be a part of that program?
No, you do have to be. You would have to be in what we call our CAPIT program. You would be someone who was convicted of domestic violence. Now, I haven't had a conversation with Equitas because they now have counselors there who handle specifically these cases. I don't know that Equitas might not allow someone who is either a victim or just anyone who feels that they need these counseling services to sign up for those services, because Equitas does provide a wide range of services. So could Equitas decide to allow someone to go to counseling? They certainly could. I don't know if they do, just because that's not something that I handle with Equitas, but they certainly could. They do have the staff there. I just don't know if that's a program they offer.
And who pays for the program?
Well, it's grant funded, and it's also funded through the county and the city. So city council, county commissioners, we have grants that we get as well to pay for it. So it's not something the defendant has to pay for.
Okay. And he's been sent to the program with conditional probation in lieu of incarceration.
Well, it's not a condition of probation. It's an opportunity, I would say. We will there a lot of times it'll be the defendant's attorney who will bring forward that a defendant may want to engage in this. I guess what you will see in domestic violence cases a lot is what we understand is I can only sentence someone to 180 days in jail on a domestic violence case. And if I put someone in jail for 180 days, I'm not solving any of the problems that may have led to the domestic violence situation. There are certainly instances where an individual has had opportunities to go to counseling and be on probation, and that hasn't worked, and jail time becomes a necessity. But we try and limit those to as few as possible. Our first option is always, hey, let's get to the root cause of the problem here as to why you are here before the court. So we offer that to an individual who's convicted of domestic violence. It becomes their decision whether or not they want to engage in that. Now, if I put someone on probation, the probation office is certainly going to order counseling as a condition of probation. If an individual decides not to do the counseling, the case then comes back before me with a determination on, well, if you're not going to do the counseling, then are we going to be looking at jail time? So most individuals, we present that opportunity that, hey, we have this program. We have this program, and it's directed specifically towards, a group of people. If you are interested, we will put you in that program. So it's voluntary. None of us as judges ever use anything like that as a, do this or else. It's, if you would like to take advantage of this, we would be happy to provide it for you. So it's voluntary to get in, but because individuals aren't naturally going to know what kind of programming we have, we let them know that it exists so that they can make an informed decision.
Thank you. You mentioned trying to figure out the root cause of why people came before the court. In the light of that, a lot of people get involved in the legal system because of some form of addictions, one way or the other. You all helped created a program for people suffering from addictions who are caught up in the legal system. Can you tell us more about this program?
Absolutely. So what happened was we had a program where we were able to get individuals what's called a Vivitrol shot. And what Vivitrol is it is a drug that was designed for people who are alcohol addicted. And it's a once a month shot. And what it does is it blocks the receptors in the brain from getting the effect of alcohol. And it also reduces and eliminates the cravings that individuals who are addicted would get for alcohol. And what they found was it also worked on opiates. So we had the ability to get this shot to individuals who wanted it, and it was not something that the court would ever make as a condition of bond or would force on individuals, but something that we would let them know was available if they were interested. And we were able to get it to people while they were still incarcerated, because we found that that was an effective way to get kind of the ball rolling. You need to make sure that someone has detoxed and that they no longer have any substances in their system before you start administering this. So for the most part, it was people who were in jail who were receiving it. We had some out of jail as well, but a lot more that were in jail. Well, for some, our funding dried up, and I can't remember exactly what happened, but needless to say, we ended up not having any funding. And what we found out was one of the things that happens when you're in jail is your insurance gets turned off. If you have government insurance, it gets turned off when you're incarcerated. So I had to think outside the box a little bit, and I thought, well, when someone's in jail, their insurance gets turned off. How quickly can we get it turned back on when they're not in jail? And we found out that, hey, you can get it turned on right away. As long as you have internet access, you can jump on the government's website and you can turn that insurance right back on. So what I said was, well, then why can't we just release the individual from jail, and they come, we just have them released, and they meet with a probation department employee right at the door when they're released from the jail, and then we walk them up here into the courthouse because the jail is located right next to the courthouse. So we would just walk them to the 6th floor of our courthouse, and there we had a nurse who would do all the prerequisite screening, and we could administer the Vivitrol shot right there on the 6th floor of the courthouse. And then what I thought was, well, if we're going to do that, let's see what other things we can do here to kind of give someone a head start on their road to recovery. So we administered the shot there on the 6th floor. And then what we did was we linked them up with their probation officer. We linked them up with their service provider. So if they're going to do counseling services, we would link them up with those services right there on the 6th floor, right when they come in. And then we expanded it even further and thought, well, what else could we get in there? And so we have job training, and if someone has food insecurity issues. So it's complete wraparound services that we have in there now. It's you know, I have a whole list of things here that we have a big flyer that we keep on the posted on the courtroom walls, and then on our self-help center that has all these programs listed on it. And pretty much everything we could think of, we thought, well, let's make this a one-stop shop. The probation officers are there. The drug and alcohol addiction teams are there. Like I said, any food insecurity issues, housing, jobs. We have all these flyers, brochures, agencies there that can meet with individuals, and it's been a great program. And then I thought, well, let's see if we can expand this to everybody, and that's what we did. So in March, what we did was we opened up basically in the same area of the courthouse, and now we changed it from the medication-assisted treatment program to the March program, so which is now medicated-assisted treatment, assessment, referral, care, and hope. And that program is now open to anyone. And so you don't have to have a case here in the courthouse. If you are having trouble with addiction issues and you want to get help with your addiction issues, you can now come down to the Franklin County Municipal Court. You can go to the 6th floor of the courthouse, and you can meet with someone, and they're going to get you on the road to getting some help. We can do the same things we would do with people who are we put on probation. We can get you the Vivitrol shot. We can get you linked up for counseling services. We can get you help with food insecurity issues, help you with housing. We have linkage with job programs. We even have linkage. The city attorney's office created a program with Columbus State where they do minor car repairs. We linked those. We brought that information in there. So it's really expanded. What we've really tried to do is, we have a lot of people who are here in the courthouse. Let's provide resources. Let's, all the outside agencies that we have, let's bring their resources here into the courthouse and kind of make us a one-stop shop for that kind of stuff. It just, to me, it made sense. And so, so it's been great. It's, the program's been up and running for about 5 months now, and it's incredible. I mean, we even have on certain days of the week, you can come down and get a social security card. You can get a birth certificate. So we've reached out to, a lot of different government agencies and said, hey, we have some space here. If you're willing to have someone come down here and sit for a couple hours a day, we have people who can definitely use your resources. And, it's a lot easier to come here and be able to link up with 5 or 6 different agencies instead of having to go out on your own and go to 5 or 6 different agencies. So it's just kind of made sense, and it's worked out great.
You talk about people coming in or walking in to be a part of this program. Is it if for someone who don't have access to the courthouse and want to know more about this program, can they find information about them online?
Absolutely. Our website, which I told you earlier, just went up within the last couple of months, has there's a drop-down tab. It's called the March program. And yeah, absolutely. You can go to the website and it will give you all that information. And 2 of the probably best resources that you're going to find here in the courthouse are both located on the 6th floor of the courthouse. and both have a wealth of information on the court's website, and that is the March program and the self-help program. Those are two things that myself and Judge Paley have really been adamant about pushing and working towards getting up and running, and making sure that they consistently have funding, and making sure that that we're able to think about other agencies that might want to get involved. You can come to the courthouse on the 6th floor there and go to the self-help center, and they will help you with, we were talking about small claims things earlier. They'll help you with things like filling out a complaint. They can't give you legal advice, but they can guide you through the process. They can help you with getting your cases expunged. Which is a huge thing. You're talking about, you can come down here, you can meet with them. They can help you fill out the application. They can, tell you where to file it. They can, walk you through the entire process of an expungement, which is huge, because a lot of people, sometimes you don't even think about, something happened when you were a teenager that might have an impact on your ability to get a job, or, you don't think about it until you're getting a job, and then, forgot I was convicted of some minor offense years ago. So the 6th floor is really is a great floor in our building. They talk of building we're going to at some point hopefully get a new building because we've outgrown the 6th floor already. We could use a lot more space because, every time you think about it, we think about a new provider coming in and getting some new information in there. You think of one and you get them in there, and then the next thing you know, you think of a couple others. I've had conversations with the county auditor's office, the county recorder's office, to say, look, any kind of pamphlet information you have that people would generally have to walk into your office to get, give us that stuff too. We have, we can put a folder on the wall and you put your stuff there. And, if anybody comes to the courthouse, to see us for something, they can also take care of any issues they might have in your offices. So we've really tried to think outside the box and be much more of what a court has ever been, at least in the 29 years that I've worked here. Things when I first started here were much different than they are now. Our bench now is so much more engaged in really trying to help people, trying to find out what's going on in someone's life that's causing them to come to the court. Let's look at the underlying problems that may be happening and see if we can't address those issues, and see if we can't solve those issues so that somebody doesn't have to come back to court. I think in the past that probably wasn't something that most people thought was a court's function. We really just, handled things in a legal manner. Someone came in, their case was resolved in one way or the other. If there was a conviction or something, or a civil case, we made a decision. If there's a conviction on a criminal case, we did a sentence. Now it's completely different than that. Now it's, hey, why, if you're here on a no-ops charge, why is it that you don't have a driver's license? What can I do to help you get a driver's license? Now, a good thing about having worked here as long as I have is I can look at the BMV's website and I can understand what the BMV abstract is. I can look at your record on the Bureau of Motor Vehicles and I can explain it to people, because a lot of times you look at that stuff and it makes no sense. So I can look at it and say, well, here's what you need to do to get your license back. And I can print them off a document and I can, highlight the things they need to do, and then help them get valid. Because, unfortunately, probably 50% of the cases that I deal with are traffic cases, and they're traffic cases where it's simply someone doesn't have a driver's license. And most of the time that is, for some reason their license was suspended at some point in their life. And what can I, and it could be a financial issue. You can get caught in a BMV trap. We've all had to deal with the BMV and nobody enjoys that. And at some point you can find yourself in a situation where the fees that you owe the BMV are simply too high for you to be able to pay. And then you're not going to be able to get your license, but you still need to work and you still need to provide for your family. So at that point, you're forcing a person to make a decision. Am I not going to drive because I don't have a driver's license and therefore I'm not going to be able to work and feed my family? Or am I going to drive? And, people make, understandably so, the decision to continue to drive, which results in a lot of driving under suspension and no operator's license cases. But there's a lot of things that we can do as judges to help people get their license back. And so we do everything we can to do that. I can authorize now, thankfully, one of the new things that we can do is I can authorize community service for an individual to apply those fees to their BMV reinstatement fees. So if you do community service, for every hour you do, we credit you with $15 towards your BMV reinstatement fees. So that helps people get their license back. And so really, for me, like I said earlier, as a judge, it's a completely different job than what it was when I started in the system. And I find it a lot more satisfying that way because I'm trying to help people. And that's what, I feel that's my, I'm an employee of the voters and the taxpayers. So I'm here to help. And that's what I enjoy doing every day. That's why I love coming here every day.
And yes, I can tell about the way you answer this question, how passionate you are about these programs. And it seems like the way the courts are set up right now, there's less judgment and more compassion. What led to that change in approach? Instead of just judging people and have them face the consequences, but now it's more about compassion and assistance. What led to that?
Well, I think probably just a lot of experience with, at least for me, you would see the same people coming back over and over for the same problem. And then you start to realize that, what we're doing isn't working. Whatever model we have here or whatever process that we're going through here, we're not achieving the intended result. Because if someone comes, before me on a no ops and I sentence them to jail, that's not solving anything. And I'm not going to put somebody in jail for not having a driver's license. Now I'm going to cost them their job, their housing. Well, at that point, I'm making their situation worse. I need to figure out a way to make their situation better. I mean, I realize that, people probably don't think that a judge is, there to help someone get their driver's license back, but I don't know who else is. And so if I look around and I can't find someone else who's going to do it, then I'll do it. I'm a captive, they're a captive audience. They're there in my courtroom because they don't have a driver's license. Well, okay, if I have to be the person that's going to step up and do it, then I will. Because, if you go to the Bureau of Motor Vehicles, they're going to tell you what you need to do, but they're not going to help you get there. I mean, they're just going to say, well, you owe this number of fees. Pay us the money, we'll give you your license. And no one wants to go to the BMV and stand in line for a couple of hours to hear something like that they probably already knew when they got there. In any of the programs that the BMV offers, I don't know how. I'm sure they're helpful, but I think we're in a position where we really understand it more and we're able to offer more help, because a lot of times the BMV will say, well, you need to go to the court and you need to get the court to do this for you. Well, so you're going to end up in front of us anyway. So, like I said, when someone's in front of me and they don't have a driver's license, I will run them through the BMV system, find out what it is that's going on and try and resolve that. And like I said, I think it's just, we realized the way things had been done weren't working. And I think the courts were doing it that way just because it had always been done that way. And, at some point I realized that, when I became, and it was a little before I became a judge, I realized, if I'm ever able to become a judge, I'm not going to handle things the way that I see them being handled now. I'm going to try and do things differently. And that's not something that's for every judge. It's individualized. For me, it just made sense. Such a high volume of my cases involve not having a driver's license or even, theft issues. You find someone stealing, $6 worth of food. That's not someone who's looking to steal because they want to steal. That's someone who's stealing because they're hungry and because they're trying to feed their family. And that's not so much a theft problem as it is there's an underlying issue there, and let's try and find out what's going on. So I think my generation has probably just realized that we want to do things differently, and that there is another way to do things, and that, hey, let's try this out. If we look at what's causing someone to come to court and try and fix that, then maybe they won't, maybe we can help change their lives. I mean, ultimately, they're going to be the ones that change their lives, but maybe we can guide them along the way. And we certainly have the ability, because we are judges, to put a little bit of fear in people. Like, look, if you don't right the ship a little bit here and you don't start to, correct behavior and maybe take advantage of some opportunities we have, then maybe you're going to force our hand and we are going to have to impose jail time. So we do have, a little bit of a bully pulpit there that we're able to use, but it just makes sense to me. And not to say that, to criticize the way things were in the past. I guess, we've just kind of evolved that, we realize that, the system should change and we should come up with, better ways to handle things.
Yeah, well, you're very right. The reality is that we have to grow. If we stop growing, then we'll start dying. And the programs you have, they are very revolutionary. It's more about taking, turning the power of the people back on the people to empower them. And thank you for that. And I'm sure there are a lot of lives that will have been changed and saved instead of just being penalized for things that they have no control over. And
Absolutely.
yeah, you are currently seeking re-election to maintain your seat, and you've been a judge now for 9 years. But from the story of your life, whether it's personal or professional, it seems like you've always been an apprentice leading to this position. What does it feel like to have to defend a position you hold now, having accumulated 29 years of experience to hold that position?
Well, it's weird. I mean, being a judge is an elected position, so it's to be expected. This will be my third term. My last term, I wasn't opposed, which is obviously that's the best way. The best way to run is unopposed. So it's a little frustrating to have someone run against you, because you do kind of take it a little bit personal that someone wants to take your job, and so that's a little disappointing, because I think I do a very good job. I think that I've talked about changing the way we do things here in the courthouse, and so unfortunately, as an elected official, your job is political. And I find, I don't feel like I am a political person, but, the reality is that it is a political job. And so therefore political parties can want to run somebody against you so that they can have someone in, their party in your job. I don't like that as so much as a judge, because I don't do my job as, one party or the other. I do my job using common sense and using the experience that I've gained from being here in the court. And I think that's what is extremely important when you're talking about who you're voting for and who you want to be in a position such as mine. I'm not creating policy. I can understand why there's always contested races in things like Congress or in the, something like that, where there are policy decisions being made, which, depending on who you elect, may be someone who's for or against a policy that that you believe, that you hold dear to your belief system. For a judge, it isn't that way, at least to me. I don't do my job with one political, party in mind. I do my job because my job is to follow the law. I don't make the law. The legislature makes the law. I interpret it and apply it. And then what I try and do is, think outside the box and do things maybe in a different way than they've done in the past to help people. And I do that through the experience that I have of having worked here for my entire adult life. I mean, there's not very many people that have worked down here in the courthouse for as long as I have, which makes me feel old. I mean, there's no judge on the bench that's been here in this courthouse as long as I've worked in the courthouse. There are judges here who have been attorneys longer, but Judge Green is the senior judge, and he came onto this court in 1995, and that was 3 years after I was here as a bailiff. Now, he was an attorney much longer, but I've been here a long time, and I've had an opportunity to learn how this courthouse runs from start to finish. I know the inner workings of the clerk's office, the probation department, the prosecutor's office. As a prosecutor, I was a county prosecutor. I handled felony cases. I conducted jury trials. I tried a bunch of felony cases. I tried cases in juvenile court. So I have a well-rounded experience, which is important when you are a judge, because you want to be able to look at a case, and if you've never tried a case in your life, and all of a sudden you're a judge, that's horrible. You should have been trained. I've learned from ground level up to get to my position. And I think that's important. I think with judges, experience is probably the most important thing. And having a diverse experience is very good. You don't want someone coming into this job who's never seen a no-ops case, and all of a sudden they decide, well, I'm going to put you in jail for 60 days because you're driving without a license. That isn't helping someone. That is more damaging than it is good. And so you can do a lot of harm if you don't understand what you're doing. And so having a lot of experience in dealing with felony cases, I handled felony cases from murder, down to F5 forgeries and drug possession cases, domestic violence cases. So, that experience matters. And you don't want someone who's becoming a judge and they've never conducted a jury trial before. The last thing I would want if I were either a defendant or a victim on a case is to have someone sitting on the bench who's making the legal decisions and they've never done that before. So it can be frustrating, when you think that you're doing the job right and you have a level of experience that someone wants to come and take your job. But at the same time, that's part of the deal. If you are an elected official, then that's what you sign up for. That every 6 years there's a chance that someone's going to try and take your job from you. And I don't know that there's any better way to do things. People talk about having appointments, and I don't know. That's for someone else to argue whether or not that's a better method. I guess I would just, you'd just rather see maybe individuals decide, this judge does a very good job, so at least I'm not going to run against him. But, that's the reality. It happens. It's to be expected. You just hope that, people educate themselves on who is running for judge and look at the level of experience the individuals have and make an informed decision.
Thank you. And for the people of Franklin County, if you're watching or listening to this, you heard from Judge O'Grady. This is a man that has spent most of his adult life in the courtroom, especially this courtroom. It was as if he's been an apprentice to become a lawyer, a judge, or magistrate most of his adult life. And as someone who, from the way he talks about the programs they have at the court, it mixes judgment with compassion. It's not about judging, but also assisting people. But the decision is yours to make. Thank you, Judge O'Grady, for coming onto Legal Angle. It's been a pleasure talking to you.
Oh, the pleasure is all mine. Thank you very much for having me. I really appreciate what you do.
Thank you. And for those of you watching us at home or listening to this in a podcast or on the radio, thank you for joining us. Until next time, stay safe.